good evening, everyone. And to those of you who are here, thank you very much for braving this evening's weather to come here. After our wonderful summer, I suppose we're used to it. But anyway, thank you for being here. It's always helpful to have an audience. And to those of you who are online, I would love to look you in the eye, but I can't see you at all. So thank you for listening. Thank you for tuning in, if that's the right phrase. And I hope what follows will be of some interest to everybody. I always find Bart's introductions a little frightening, to be perfectly honest. High office is a very relative thing. And high office within the school is something, but it's not exactly President of the United States either, or even President of the Supreme Court. So I said I'll talk about fact, fiction and philosophy, and a bit about how case law shaped a nation and to some extent the world. And I took as a starting place the Clapham Omnibus, the man on the Clapham Omnibus, for two reasons. He's a well-known figure to law students everywhere and to lawyers and indeed to judges, because he provides a reference for understanding how the law works. And I think he's also a well-known name, at least to persons who are not so well versed in the law, but who recognize that there's something about what you might call the common man, which has a particular relevance to English law and the way that English law works and the way that it's spread across the globe. And I want to talk about two incarnations of this character, the reasonable man of the law, as he's known. The first is often referred to as the man on the Clapham Omnibus. The second, in this particular account, takes the flesh and blood form of a woman with a placard on the street outside a Crown Court in the London borough of Southwark. And you'll find they're very different characters. Not merely because they're different genders, but because they have very different roles within the lawmaking process. But they are, in their way, they're both creations of the common law of England, and they have a common ancestry. But they do have, as I said, very significant differences. And the first appearance of the man on the Clapham Omnibus in English case law was in fact as late as 1903. He was recognised by a judge in a libel case, and the case was brought by an impresario who complained about a critic's view of a performance at the Theatre Royal in Plymouth. The play was called The Major. I tried to find The Major online and it had vanished without trace, which is not surprising, because this is what the review said, some of what the review said. He called it a three-act absurdity, composed of nothing but nonsense, of a not very humorous character, whilst the music was far from attractive. And he added, it would be much improved had it a substantial plot, and were a good deal of the sorry stuff taken out of it. Well, it went on in this vein for the length of a fairly short report in the Western Evening News. But the impresario was also the playwright and a leading performer, and perhaps not surprisingly, took offence, to such an extent that he thought he would sue the Western Evening News for libel. And at first he succeeded. The matter went to a jury. They had jury trials for these sort of things in those days. They occasionally do even now for libel. And he was awarded £100 damages. So the Western Evening News appealed. And it came before Lord Collins in the Court of Appeal. And he had this to say. One thing, however, is perfectly clear. I think I've got this on a slide for you, so let's see. Yeah, one thing, however, is perfectly clear. And that is that the jury have no right to substitute their own opinion of the literary merits of the work for that of the critic. or to try the fairness of the criticism by any such standard. Fair, therefore, in this collocation certainly does not mean that which the ordinary reasonable man, the man on the Clapham Omnibus, the juryman, common or special, would think a correct appreciation of the work. And it's of the highest importance to the community that the critic should be saved from any such possibility. He went on to declare that the review was fair comment and an honestly held opinion, and therefore could not be a libel. And he related it, in fact, to the right to free speech, and the fact that it is actually open to us to have a view about things that are presented to the public and to say what our views are. And it was interesting. I thought, oh good, I found where the man in the Clapham Omnibus comes from when I was researching this and trying to find him. But of course, in this case, he was not the standard that was taken. The standard that was taken was a little bit different, because the judge here is saying it doesn't mean that which the ordinary reasonable man, the man on the Clapham Omnibus, would think a correct appreciation of the work. The issue was quite different. It was whether it was a fair comment. So anyway, he hovered around in the fringes of the law for another 30 years until a more serious case, a much more serious case called Hall and Brooklands Auto Racing Club. That was in 1932. And in that case, a spectator at Brooklands Racing Stadium, the stadium racing track, or a number of spectators, in fact, were in the crowd. They were watching, and a car came off the track, came through the barriers, and injured several people. And the question was whether the race organisers owed a duty of care to the victims of this accident. And in that case, a Lord Justice Greer again invoked the man on the Clapham Omnibus, describing him as that ubiquitous and mythical reasonable man, whose purpose was to set reasonable standards. And in this case, the judge decided that the reasonable man would say, well, actually, no, because an ordinary reasonable spectator would know quite well that no barrier would provide protection from this possible but highly improbable occurrence. Thus, the reasonable man in that particular case denied any right of compensation to the victims, a result which I think will be very unlikely now, 100 or so years later. In fact, in another case decided in the same year, the whole temperature changed. The House of Lords, as it then was, came to a different conclusion, without actually calling on our Clapham man, but clearly invoking his spirit. And that was the well-known case of Donoghue and Stevenson. At least it's well known to anybody who's ever heard a lecture on law, but if you haven't heard of Donoghue and Stevenson, it's the famous case in which a very unfortunate lady was given a bottle of ginger beer by a friend in a cafe in Paisley in Scotland. You need all these details. And she poured out half of it and consumed it, and when she poured out the rest of the bottle, the decomposed remains of a snail came too. Not only did she suffer from severe shock, she also suffered from severe gastroenteritis as a result. And she thought she should sue the manufacturer of the ginger beer because the manufacturer had bottled it. And I'm sure you all know those ginger beer bottles, they're opaque things, you can't see what's inside them. And so there was no way that the cafe owner or anybody else could have known what was in that bottle until it was emptied. Well, the whole question went to the House of Lords on a preliminary point as to whether there was in fact a cause of action. Because in strict law, there was no causal relationship between the ultimate consumer of the ginger beer and the manufacturer. There was a series of contracts which could have given rise to legal liabilities all the way to the friend who bought it. But a gift is not a contract. So there was a gap, as it were, in the chain of legal relationships. And this came up before one of the great judges of the 20th century, Lord Atkin, who in his leading judgment had this to say: "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. That is to say, to persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when directing my mind to the acts or omissions that are called in question." Notice 3 references in 2 sentences to reason and reasonableness, and by implication to the reasonable man of the law. And notice that it's us who are expected to be reasonable. And this is a theme that has run through the common law since ancient times, at least relatively ancient times. Medieval times is perhaps better. And this test came to be known as the test of reasonable foreseeability, also as the neighbour principle, based on Lord Atkin's reference to the neighbour principle, the rule that you're to love your neighbour. As he said, becomes in law, you must not injure your neighbour. And this, in a way, was in fact a description, a definition of what the law meant by your neighbour. Someone whom you might reasonably have in contemplation whenever you do anything, basically, as being affected by what you do or do not do. So that was the test of reasonable foreseeability. Just to, I think, help us along a bit and get into a more obscure and strange area of the law, he reappeared, the man on the Clapham Omnibus, in a case in 2014, in those wonderful old days when there was such a thing as European law. Do you remember those? In 2014, this was a judgment of the Supreme Court, and the case was all about an argument about whether an invitation to tender for some, to supply some healthcare goods to a health authority had been sufficiently clearly expressed to be understandable in the same way by everybody who read it, because there was a European directive that said that in order to be fair, you had to make it clear to everybody who was likely to tender for a particular contract what it was they were tendering for and what was expected, which is not actually an unreasonable condition when you think about it. It's an attempt to make sure that everybody is tendering on a reasonably level playing field. And in this case, the people who had had the previous contract, which had expired, tendered and didn't get it, which obviously had an impact on their business. So they complained that the rules weren't clear enough. Lord Reid opened his judgment with these words: "The Clapham Omnibus has many passengers. The most venerable is the reasonable man, who was born during the reign of Victoria, but remains in vigorous health. Amongst the other passengers are the right-thinking member of society, familiar from the law of defamation, the officious bystander, another description, the reasonable parent, the reasonable landlord, and the fair-minded and informed observer, all of whom have had season tickets for years, many years." And he goes on, "The horse-drawn bus between Knightsbridge and Clapham," so not the one I showed you on the picture, but they don't use the horse-drawn one anymore. The horse-drawn bus between Knightsbridge and Clapham was real enough. But its most famous passenger, and the others I have mentioned, are legal fictions. They belong to an intellectual tradition of defining a legal standard by reference to a hypothetical person, which stretches back to the creation by Roman jurists of the figure of the bonus paterfamilias, the father of the family, who apparently in Roman law had very considerable power. He was generally the eldest male member of the family. And he goes on to quote Lord Radcliffe in another case, saying, "The spokesman of the fair and reasonable man, who represents, after all, no more than the anthropomorphic conception of justice, is and must be the court itself." Or in other words, the judge. And it's for the judge to determine, as it were, objectively, whether particular acts or omissions are reasonable or not. And I find that interesting, that this person turns out to be an abstract fiction. Nevertheless, a useful one, and very much employed in all sorts of areas of the law, but nevertheless, it's a kind of notional standard, an ethical standard, and a standard of conduct based on the idea of just simply being reasonable. And I wondered, where did this chap come from? It's described in the earlier judgment as appearing as a man in the Clapham Omnibus in the Victorian time. And it appears that there was an MP for Battersea and Clapham in about 1850 who used the term "the man on the Clapham Omnibus" in Parliament. But as I say, its first appearance in a law report was in 1903. But that was his first appearance in that particular guise. I think its origin is to be found actually, if not earlier than this, at least in the 17th century work of Sir Edward Coke. He was Chief Justice of England at the time of the accession of King James I of England and VI of Scotland. And as you know, King James inherited the throne after the death of Queen Elizabeth I, who in turn inherited the throne with a little bit of an intermission from her father, King Henry VIII. And for about 80 years, the English kings, well, king and queen, had ruled with more or less absolute authority and a very compliant parliament and a very compliant judiciary. And now there was a new king. And the new king came from Scotland, where there was quite a hint of the Roman tradition because of the connection between Scotland and France. He was accustomed to rule in Scotland effectively on the notion of being there by divine right, and as being really being top dog. So the Chief Justice was faced with a king who thought he had absolute power. In the wake of 80 years, incidentally, of people who upset the monarchy being summarily executed, taken to the Tower and treated in all sorts of abominable ways. However, he quite dispassionately reports what happened in his own law reports, which are still sometimes referred to. And this is how he puts it. A controversy of land between parties was heard by the king and sentence given. He doesn't say what the controversy was or what the decision was, but controversy was heard by the king and sentence given, which was repealed for this, that it did not belong to the common law. Then the king said that he thought the law was founded on reason, and that he and others had reason, as well as the judges, which you might think was a perfectly reasonable proposition. Well, this was answered by Lord Justice Coke, who said, true it was, he's very diplomatic, true it was that God had endowed his majesty with excellent science and great endowments of nature, but his majesty was not learned in the laws of his realm of England, and causes which concern the life or inheritance or goods or fortunes of his subjects are not to be decided by natural reason, but by the artificial reason and judgment of law, which law is an act which requires long study and experience before that a man can attain to cognizance of it. Those are his words, not mine, but you get the gist. And he went on to assert, I'll come back to this a bit later, but in the same report, he went on to assert that the law was the golden metwand and measure to try the causes of the subjects, and which protected his majesty in safety and peace. Well, with this, the king was greatly offended and said that then he should be under the law, which was treason to affirm, as the king said. To which Lord Justice Cooke replied that Bracton saith that the king must not be under any man, but under God and the law, for the law makes the king. Bracton, incidentally, wrote that principle in his book in the year about 1250, one of the earliest extant books of English law that we have. And you see there, don't you, there's this sort of abstraction, this specialist reasoning of the law that takes it out of every man's ordinary reasoning and, as it were, into the realms of abstract reasoning with the intent of fairness. And as I said, it's actually a very useful tool. But this Clapham man, this reasonable man of the law, has another ancestor who is a very long way from being described, oh sorry, I should have put that up for you. He's a very long way from being described as an anthropomorphic conception of justice. And his cousin is the woman I referred to with the placard in Southwark. She too owed a great deal to the common law and to a much more down-to-earth conception of what it is to be human, at least in the eyes of the law. She at least was a real person whose presence and actions invoked about 1,000 years of common law history. This is because Richard O'Sullivan, as Richard O'Sullivan put it, he was a King's Counsel who was at the top of his profession in about 1950. He described it this way: the common law starts with man as he is, the man in his actual constitution, as a reasonable being, the reasonable man of the law. Man, thus considered, is a being of spirit and of sense. Every man is accordingly a reasonable man, and by virtue of his nature, free. For freedom is rooted in reason. It's an interesting principle, isn't it? Freedom is rooted in reason. And it's not too hard to see the effects of an irrational approach to freedom. It does actually need a certain amount of direction. So, you see, the common law, I think, in its original conception, its medieval conception, was never really intended for abstract judicial concepts. It was really intended for the common people, for the ordinary people, people of flesh and blood, with their hopes and their fears and their values and their intentions and their long-established ways of life. And what the law, as determined by judges through cases decided in the courts, what it did was to presume that such people did have certain qualities or attributes in common with each other, and that the law derived from a proper understanding and application of those attributes. And reasonableness and freedom were at the heart of the matter. It's an interesting reflection that free men were not, in fact, the largest portion of a society in the medieval times, but nevertheless, it was taken to be, as it were, the basis for the development of the common law. It started under the reign of Henry II. No one that I've found, at least, is quite sure how it emerged, but it appears that it did. And so widely recognised are some of these qualities and attributes that this common law of England has been described as the common heritage of mankind. And it has spread to many parts of the globe, carrying with it ideals of justice, equity, freedom, and reasonableness, as well as practical ways of expressing and preserving and enhancing them. And it developed over a long time. It wasn't that somebody suddenly came up with this idea, wrote it all down and said, here it is. It took a long time to develop. But I think at the very heart of it, there is the idea that any person is free to go about the lawful business of life without interference by anybody, neither the king, nor government, nor even fellow citizens. You could perhaps sum it up as live and let live, but that's only possible if certain conditions apply. And this idea dates back to at least the 8th century. For example, King Alfred the Great wrote, and he wrote some laws, but he did it on this basis. Where are we? I dared not presume to set down in writing many laws of my own, since it was unknown to me what would please those who would come after me. So that was his starting place, not too many laws. But he did write down one law. He said, what is most necessary is that each man keep carefully his oath and his pledge. Well, that's had all sorts of ramifications. The law of contract, for example, is based on my word is my bond. To this day, and all sorts of things have arisen around it to try to make that proposition real in the law of contract, and to mitigate the consequences when sometimes it's not as easy as it might have appeared. But more pertinently, for present purposes, to begin with, every judge in England is required to take an oath of office on appointment. And the oath is this: it is to well and truly serve our sovereign King, Charles III, and to do right to all manner of people, after the laws and customs of this realm, without fear or favour, affection or ill will. And everyone who attains to any form of judicial office in England takes that oath. That's the basis of their service as a judge. From the district judge in the magistrates' court or the local county court to the president of the Supreme Court. They're all bound by the same oath. But of course, as you know, in court systems, oaths don't stop with the judge. Witnesses take their well-known oath to tell the truth, the whole truth, and nothing but the truth. And jurors also swear an oath to faithfully try the defendant and give a true verdict according to the evidence. And I doubt if any of them gives a single thought to the possibility that they're actually following a law which was laid down by King Alfred the Great in the 8th century. But there it is. And it's pertinent to Our Lady with the placard in Southwark, because on the 27th of March last year, at the Inner London Crown Court, there was a trial due to take place of some members of an organisation called Insulate Britain. They were climate change protesters, and they were causing a public nuisance by stopping traffic. And they were prosecuted, and they were brought to trial at the Inner London Crown Court, and the trial was by judge and jury. So about 8 o'clock in the morning, before the trial was due to start, it was a Monday morning, I think, a lady called Trudy Warner appeared in the street outside the court entrance. It's used by jurors and judges, and she carried a placard. And it read, "Jurors, you have an absolute right to acquit a defendant according to your conscience." And it appears she remained in the street for about an hour, not stopping or bothering anybody, just holding a placard. And there's no reference to anything that she did in anything that she did to any particular trial or any particular defendant. She was just standing in the street with a placard. albeit not any old street and not any old placard, but nevertheless. News of this conduct reached the Solicitor General, one of the government's law officers. And she decided that she would bring a civil action against Miss Warner on the grounds that her actions interfered with the right of jurors to go to and from the court and perform their duties without let or hindrance, and that it thereby interfered with the administration of justice. And it was alleged that these acts were done by Mrs. Warner, or Miss Warner, with the specific intention of interfering with the administration of justice by seeking to influence jurors, and in particular to acquit climate change activists, whether or not such an acquittal would be in accordance with the judge's legal directions. So the proceedings against Miss Warner were based on an offence called common law contempt. That is, contempt of court. And unusually for civil cases, the courts have power to imprison people for contempt of court. So there was quite a lot at stake for Miss Warner. But partly because of the severity of the consequences of a conviction, which it would have been, as a matter of civil procedure, actions for common law contempt can only be brought with the permission of the court, the High Court. And in order to get permission, the Solicitor General had to show that she had a reasonable basis in fact and law for pursuing the proceedings. Note once again the reference to reason and reasonableness. Well, the civil court in this case was the Court of King's Bench. And on the 22nd of April, the case came before a High Court judge in the King's Bench division on an application for permission to bring the proceedings, which, if successful, could have resulted in Miss Warner being committed to prison. And nearly everything in this case touched upon the common law and its origins. First, there was a circuit judge sitting in the Crown Court in the original trial. The judge was one of His Majesty's judges appointed to administer justice in the King's name and in the King's Court, now called the Crown Court. But it's a descendant of the Curia Regents of King Henry II. It was he who invented the circuits. He died in 1189. And he famously required his judges to leave London and go on their journeys around the country where they would hold court sittings. They were called assizes, from the French for to sit. And their purpose was to decide cases according to the customs of the places they visited, having regard to the law of the land, and in those days also to the law of God or the natural and moral law. Because, of course, they'd nearly all been educated and trained by the Church, which at that time was the Roman Catholic Church. So the judge on the permission application was a High Court judge of the King's Bench division, and that remains, as it's always been, a court of common law, also administering justice in the King's name. Because the King, in a way, is the fountain of law and justice, although he has very little direct power to do anything about it. Then, of course, there was a jury in the original trial. It's not clear that King Alfred actually had juries in the modern sense, but he certainly did call upon local people and councillors to advise him as to how to deal with cases. And the engagement of communities in the administration of justice was well established even before the time of Alfred the Great. The earliest reference that we have to actual jurors was in a book attributed to a man called Ranulph de Glanville, who was another Chief Justice. He was writing in the early part of the 12th century, and he describes juries as consisting of free and lawful men. It's the first reference we have to the free and lawful man of English law. The free and lawful men of the neighbourhood, who would be gathered to decide upon disputes among citizens. And the basis of that was that they would be most familiar with the customs and practices of the locality, as well as with the protagonists in cases, and were therefore most likely to be able to arrive at just decisions in local disputes. So we hear from Glanville, the first great concept of the common law is the free and lawful man whom we meet in Glanville. Among laymen, says Maitland, the time has indeed already come when men of one sort, the free and lawful men, can be trusted as men of the common, the ordinary, we may perhaps say the normal sort, while men of all other sorts enjoy privileges or are subject to disabilities which can be called exceptional. The lay Englishman, free but not noble, who is of full age and who has forfeited none of his rights by crime or sin, is the law's typical man, typical person. So it's an old notion. And in a way, it's one that's run through the way English history has developed. I should add that it hasn't all been sweetness and light. There are other aspects which are less desirable, but nevertheless, there are these aspects in the common law which one sometimes loses sight of in the comings and goings of the everyday world, particularly in the modern climate. So we note the qualification. They were free and lawful men. They were not serfs or slaves or villeins or even noblemen. They were the ordinary people of the time. And they were the ones who decided what the local customs were and how they applied. And as a result, they came to be regarded as the normal person that the laws were there to support, to protect, and, where necessary, to restrain. But to return to Miss Warner and her case. Not only were the two judges and a jury involved, there was also an officer of the Crown, a representative of the Crown, the Solicitor General. A fact which also called into play the long-established principle of common law that I already referred to, namely that the king ought not to be under man, but under God and the law. So even a senior government minister had to go to the court to get permission to bring proceedings. And as I said earlier, we first hear of that principle in a book called Of the Laws and Customs of England, which was written by Henry de Bracton in about 1250. It was obviously an important point. It echoed the Great Charter, the Magna Carta. You'll remember the famous words, "To no one will we delay or deny either justice or right." And also, of course, we owe it to that charter the principle that no one shall be imprisoned or have their possessions taken except by lawful judgment of their peers. And in accordance with this 900-year-old principle, everyone is entitled to due process of law, including, of course, Miss Warner and her placard outside the inner London Crown Court in March last year. And of course, if the King is under law, so is the Solicitor General, an officer of the Crown appointed by His Majesty's government. And that's why she couldn't just act as a minister on her own authority. It's because the spirit of the law is that people are free to conduct themselves as they see fit, without interference from government ministers, except in accordance with due process and provided that they don't cause harm to others. It's not an unqualified freedom. I always like the phrase, we used to use it a lot in the school, that my freedom to swing my umbrella stops at the end of your nose, which I think expresses it very succinctly. And of course, Miss Warner herself matters. Like the prospective jurors, who may or may not have seen her placard, she is a direct descendant of the free and lawful men of medieval times. But she's also a private citizen, faced with the might of a government department, which called into play another ancient principle of the common law, namely the principle of equality before the law. not only is every man, but as we now realize, every person of whatever gender, equal in the sight of God, but more prosaically, they are presumed also to be equal in the sight of the law, an equality which actually is very difficult to achieve in practice, but which nevertheless is there in principle. And this means that the law has to find ways to balance the power of the state with the vulnerability of the individual. And this is done by maintaining a rigorously independent judiciary, acting in accordance with their oath to do right to all manner of persons without fear or favour, affection or ill will. And of course that independence of the judiciary is part of what has shaped not only the development of the British Constitution, but of constitutions all across the globe. And it was demonstrated most recently in 2022, when Mrs. Miller took the Prime Minister, Mr. Johnson, to court when he tried to prorogue Parliament for an exceptionally long period. It was a matter of several weeks instead of the usual several days. And the Prime Minister argued that the proroguing of Parliament was an exercise of the royal prerogative, and therefore that the courts had no power to interfere. The royal prerogative is a collection of powers that remain with the king, I think it was then the queen, which can be exercised in their own right as monarch. But it has to be exercised lawfully. The Prime Minister argued that proroguing Parliament was an exercise of the royal prerogative, and therefore that the courts had no power to intervene. The court did agree that it couldn't interfere with an exercise of the royal prerogative, but Mrs. Miller argued successfully that the Queen, being under the law, could only exercise the prerogative lawfully, on the basis of lawful advice from the Prime Minister. She also argued that the advice that she could extend the usual period was unlawful, and therefore void. The Supreme Court agreed unanimously, all 11 judges, with that argument, and declared that because the advice on which the Queen had acted was unlawful, the prorogation was void and of no effect. Parliament had not been prorogued after all. So the Queen and the Prime Minister remain subject to the law. And it does, I think, indicate, doesn't it, the importance of the independence of the judges, that they do not have to be frightened even of the Prime Minister. After all, in fact, the worst that can happen is that the Prime Minister can go back to Parliament. But I'll come to that in a moment. The judges, though, are no respecters of persons. And this is what it means to do justice to all manner of persons without fear or favour, affection or ill will. And there are cases every day that demonstrate this, often involving Home Secretaries and their departments, because they frequently do their best to stretch the limits of their lawful powers. And they're held in check day by day by judicial process. And of course the newspapers love it, because there's a big tension, the government's trying to get something done and the court's saying they don't have power to do it. They can always get power to do it if they can persuade Parliament. That's the point of a democratic system. But there are two other things to note, I think, about the free and lawful man of the common law. The first is, of course, that he was presumed to be reasonable and to act reasonably. We may think that's a rather hopeful description of the man in the street, as we would now call him, or the person in the street. But nevertheless, it is presumed that normal people are reasonable and act reasonably. And that's a continuous theme through the whole development, the whole history of the common law, prompting Sir Edward Coke, as we've heard, to declare that the common law itself is nothing else but reason. And of course, a similar principle is echoed in the requirement for permission to bring proceedings against Mrs. Warner, that there has to be a reasonable basis in fact and in law for bringing the proceedings. And again, in the requirement that a jury, or indeed any other tribunal, be satisfied beyond reasonable doubt that a person is guilty on the evidence that they've heard before they convict. It pops up all over this place, this presumption of reasonableness. And I think it's worth really emphasising, if they haven't noticed, we are all presumed to be reasonable persons by the law and to act reasonably. I'm fairly sure that's the reason why there's another principle, which is that ignorance of the law is no excuse. Because if you're acting reasonably, you won't transgress the law. Ignorance of regulations is another matter. But we'll come to that in a moment. There is a second presumption worth noting about the free and lawful man. We haven't got that far yet. Here we are. The second presumption is, as Lord Denning described it, the golden metwand by which all our rules of evidence and procedure are measured, is that no one shall be found guilty unless his guilt be proved beyond reasonable doubt. Even if he is in fact guilty, we care not. His freedom is not to be taken away unless he is proved to be guilty. It's called the presumption of innocence, and in its modern form, it only really came into being at the beginning of the last century. But even before then, the principle was clear that if you were going to prosecute someone and invoke the law against them, you had to prove their guilt beyond reasonable doubt. And so here we are, free, reasonable, innocent people. That's the assumption that the law makes when you walk into the courtroom. And I think it's right to say that the law was at its really most creative during the medieval period, because then it was possible to assert that it really was born out of the customs of the people, mostly as they applied to free and lawful men. And those customs were applied and developed, as I said, in the light of the law of God and the law of nature, as understood by the Holy Roman Church. But it all came to an end with the execution of Sir Thomas More in 1532. I dare say many of you have seen the film, The Man for All Seasons, which depicted his stand. He was Lord Chancellor at the time. He was a devout Catholic. And of course, he refused to pronounce upon the lawfulness otherwise of Henry VIII's divorce from Catherine of Aragon. And he was executed for saying nothing. And that was really the start of the Tudor tyranny. Because when the king can execute the highest judicial officer for basically not complying with his wishes, you have set the king above the law. And that was the basis, I think, of the whole Tudor tyranny. I dare say historians would develop with more nuance, but I think that will do for present purposes. It set the king above the law, which gives another, I suppose, nuance, doesn't it, to Sir Edward Coke's stance, faced with a new line of monarchs, that he asserted the rule of law. Well, Coke's attempts through the law and the legal system to reassert the supremacy of the common law and of natural law was actually overshadowed within a few years by King Charles I's quarrels with Parliament, and then by the Civil War and the eventual restoration of the monarchy on very strict terms. They were particularly on terms that made Parliament, more precisely described as the King in Parliament, the supreme power in the state, with the sole and almost despotic power to make laws. What remained for the judges and the courts was the role of interpreting and enforcing laws made by Parliament, and also, of course, the existing common law, but they were no longer quite the creators of law that they seem to have been during the earlier medieval period. And under this new regime, the law of God and the law of the church ceased to feature, and the natural law also ceased to be of significant authority, because under this new regime, Parliament had become the supreme lawmaking power then as it is now. So from then on, the goodness and effectiveness of the law relied on the goodness and goodwill of parliamentarians. But the genius of the common law still seems to have pervaded this new constitutional settlement. To begin with, no single part of Parliament, whether it's the King or the House of Lords or the House of Commons, is able to act alone. They have to act together. And then the writ of habeas corpus was preserved. It allowed the courts to review the lawfulness of any attempt to detain or imprison citizens. It had its origin in the Assize of Clarendon in 1186. So again, a long-standing principle of the common law. And it was carefully preserved in the Habeas Corpus Act of 1679, and it continues to this day to be one of the bulwarks of civil freedom. It's still in force, and its spirit lives on in the Bail Act of 1976, which requires that if anyone is to be held in custody, they must be brought before a court and have the matter considered by a judicial authority within 24 hours, or sometimes a bit longer if circumstances allow. But the spirit of the thing is still the same. We don't detain people in this country basically without lawful authority to do so and without a proper lawful review. I dare say that it doesn't work perfectly, but it's still one of the major bulwarks, one of the major supports of our sense of freedom. And the logic and the spirit of the common law continues to be felt and continued to. Even during the Tudor time, there was a lawyer called Christopher St. German, who wrote a book called The Doctor and Student, which was a discourse, a dialogue about the law. And he was addressing at one point the lawfulness of the status of a villein. And a villein was one of those people who did not have all the privileges of a free and lawful man, and was in effect owned by a landowner or the lord of the manor. Not quite a slave, but nevertheless, he was a bondman. He was bound to stay where he was. And Christopher St. German's observation on this was that methinketh a man loveth not his neighbour who doeth so to him, which again is a kind of spirit that's alive in the way that the law applies. And it was applied in 1772 in the case of James Somerset. James Somerset, and some of you have heard me on this subject before, but James Somerset was a slave. He had an English master. He was on a plantation in Virginia. He was some kind of household slave, and his master decided to come back to England for business purposes and brought his slave with him. James Somerset did not have a good voyage. He fell ill. He was injured. And when he arrived, he was effectively useless. So his master cast him off. But he came to the attention of members of the Anti-Slave Trade League, who provided for him and nursed him back to health. And one day he was walking down Cheapside, not a mile and a half down the road there, when he came upon his former master, who immediately grabbed him, marched him to a ship moored on the Thames and clapped him on irons, reclaiming him as his property. Fortunately, the Anti-Slave Trade League found out about this. And so they moved a writ of habeas corpus requiring the slave owner to bring the slave to the court to justify his continued detention. The matter came before Lord Mansfield. Lord Mansfield was one of the great judges of the 18th century. And Lord Mansfield had a great deal of difficulty with this case, not least because there were a large number of enslaved people in England at the time. But he was being effectively asked to give effect to the writ of habeas corpus. And it's not entirely clear who said this or quite in what circumstances, but in the course of it was expressed in this way. The air of England has long been too pure for a slave, and every man is free who breathes it. Well, the slave was set free, and so were about 27,000 other people, although giving them the right to be free didn't provide them with the means to be free, and so the actual disappearance of effective slaves took a lot longer. We saw a repetition, a rather horrible repetition, of the same thing with the emancipation of the slaves in the United States, when they were simply cast off without a penny, without a place to live, without work, without any means of support, without anything. And there was a long period of real difficulty and destitution for formerly enslaved people as a result of that kind of instant translation into a degree of freedom, at least legal freedom. Well, it's cases like this over several centuries that set out rules for protecting citizens against the power of governments by establishing, among other things, a basis of personal freedom. So we can expect to be free from torture, from arbitrary detention, from arrest, from oppression, and of course freedom to think and reason for ourselves. All of those have actually come up before the courts in one form or another and been decided and upheld as principles of living a free and lawful life here in England and in the United Kingdom. And they were all the subject of common law cases over the course of centuries. And certainly central to it was the notion of independence, especially independence of judges and jury. One of those cases, I'll just go into one of them, because otherwise we'll go on all night, was Penn and Mead's case, also known in a slightly different guise as Bushel's case in 1670. And it's relevant to Mrs. Warner's case because the situation was that William Penn and William Mead were Quakers. And there was a law at the time forbidding assemblies of more than a handful of people in any public place. And being Quakers, they wanted to hold Quaker meetings, and they did so in public places. And the meetings were much larger than were allowed. So they were arrested, and they were brought before the court, and they were brought before a jury. And the judge, in effect, told them that these people had been addressing a meeting which was much larger than was allowed, and therefore they must be guilty. The jury refused to convict. And there's a plaque in the Old Bailey which commemorates this event. And this is what it says. Near this site, William Penn and William Mead were tried in 1670 for preaching to an unlawful assembly by the Gracechurch Street. This tablet commemorates the courage and endurance of the jury, Thomas Vere, Edward Bushel, and 10 others who refused to give a verdict against them, although locked up without food for 2 nights and were fined for their final verdict of not guilty. The case of these jurymen was reviewed on a writ of habeas corpus, and Chief Justice Vaughan delivered the opinion of the court which established the right of juries to give their verdict according to their convictions. And that has been the established law of the land since 1670. So you may wonder what the problem was with Ms. Warner standing outside the court saying, jurors, you have an absolute right to acquit a defendant. I can only quote what she actually said. And it's interesting that the plaque is outside the court in the Old Bailey. The lady was outside the court at Inner London, and the Solicitor General objected. Well, the principle was reiterated in another, more recent case. In this case, the last word should rest with the last word should rest with the jury remains, as Sir Patrick Devlin said in another case, an insurance that the criminal law will conform to the ordinary man's idea of what is fair and just. If it does not, the jury will not be a party to its enforcement. The executive knows that in dealing with the liberty of the subject, it must not do anything which would seriously disturb the conscience of the average member of Parliament or of the average juryman. I know of no other real checks that exist today upon the power of the executive. And he went on to conclude that it was not unlawful to accurately communicate the bare principle of law to potential jurors in a public forum. So Mrs. Warner was duly acquitted. The case against her failed. The case against the protesters, incidentally, also collapsed because the jury couldn't reach a verdict. Whether the two incidents are linked remains a mystery because we're not allowed to know what happens in the jury room. But you'll see that that spirit of the common law, it remains active, it remains alive, and it remains a thing of real people, not just a judicial concept. You see, there are both aspects. Both matter, both are helpful, both are very real and alive and part of the heritage that we have now. Again, about 70 years ago, Richard O'Sullivan quoted another MP, Douglas Jay, saying, "In the case of nutrition and health, the gentleman in Whitehall really does know better what is good for people than the people themselves." After all, they've seen the statistics. And he went on, O'Sullivan went on to describe the outcome of this attitude. The common law conception of a man, stalwart, independent and self-reliant, is being replaced by a new concept, the statutory man, a creature whose vigour is retarded by a maze of regulations, but who is said at least to be better cushioned against the buffetings of life. He also made some comment to the effect that a long and expensive education at state expense still couldn't raise a person to the level of ordinary moral competence, such that they did not have to rely on the state to tell them what to do and where they should go. But that's little by the way. But the thing is that the more the state intrudes in every aspect of life, the more powerful the state becomes, which I suppose is fine if the state is benign. But at the same time, the more vulnerable people become to abuses of power. And this has made it necessary to spell out in much more detail than previous generations found necessary just what it means to be free. And I think this was particularly obvious and pertinent at the end of the Second World War. The need then was really stark. Because if you just go back to that time in imagination, in the second half of the 1940s, imagine the state of people. They've been at all-out war, and they've seen all across Europe, in Russia and in Asia, people perpetrating the most extraordinary inhumanities through the offices of totalitarian governments. They'd seen the Holocaust, they'd seen the concentration camps, they'd seen the genocides and all the horrors of war. And they were emerging from that. And you could see that these had involved a wholesale contempt for any noble or civilized conception of what it is to be human. You don't herd people into cattle trucks and send them off to gas chambers if you have some decent, noble conception of what it means to be human. And in that state of shocked conscience, one result was the Universal Declaration of Human Rights. which was adopted by the United Nations in 1948, and it was developed for practical purposes into the European Convention on Human Rights, which was first ratified. The first people to ratify it were the United Kingdom in 1951. And I'm told that it was mostly drafted by officials at the British Foreign Office. And it's worth just noting in outline what these declarations are saying and what they're doing, because they're very familiar to anyone who's familiar with the common law. There's an obligation to respect human rights. In other words, to respect your neighbours. There is the right to life. That is, the right not to be arbitrarily deprived of it. There are prohibitions on torture, slavery, forced labour. The right to freedom, the freedom I've been talking about all evening, is expressed. And to security of person. That means security from the arbitrary actions of government. There's the right to a fair trial, which we saw exemplified in Mr. Warner's case. And there's the right to no punishment without law, similarly exemplified. And there's more. Respect for private and family life, freedom of thought, conscience, religion, freedom of expression, freedom of assembly and association, the right to marry, and the right to effective remedies in law, and so on, and the prohibition of unlawful discrimination. All of these have their origins in cases brought before British courts under the English common law. I think every one of them can be traced back in some form to cases which were decided by common law judges in common law cases, giving expression to the position in society and under law of the free and the lawful person. And I think it's quite important to recognise that these statements of rights are doing that. They're trying to describe something which is, in a way, not readily describable. But when it comes to it, the law does actually have to make decisions like that and say, well, being a free and lawful person means you can do this, you can't do that. And that's what lawyers have to do. That's what the law has to do. It's what it's there for. And in doing so, it shapes and preserves a conception of what it is to be human. And I think in a way that's the great legacy of the common law, that it gives us a notion of what it is to be human. And the courts have to maintain a proper balance, which is why there's reference to some anthropocentric conception of justice, epitomised by the man on the Clapham Omnibus, because the judges need that standard. But there's also us, and the way we behave and the way the law allows us to behave, because it's just as the law makes the king, the law makes all of us if we remain free and lawful persons. It is what confers freedom under law. And so, as Richard O'Sullivan concluded, the ordinary man of the law, who is the despair of the gentleman in Whitehall, may yet be the hope of the world. Well, I think that's as true now as it was when it was written 70-odd years ago. And that's what I have to say for now, and I've taken longer than I should have done to say it. So thank you very much for your patience.